Before we even hear the first word from the courtroom, let's slow this down for a second, because what you're about to watch is not just a custody hearing, it's a pressure cooker. We have two parents still legally married. No finalized divorce, a child caught in the middle, and a courtroom that's about to make a decision that could shift everything. On one side, a father asking for a drug test he says is about protecting his child. On the other, a mother saying this request isn't concern, it's control. And what makes this case especially tense is how quickly it escalates from routine temporary orders into accusations of manipulation, domestic violence, and substance use, all before a final ruling is even on the table. The judge is trying to keep this moving, but emotions are already spilling into the record. Pay close attention to how each party explains their position, what they don't say, and how the court reacts. Because by the end of this hearing, a single decision will redefine custody, credibility, and trust moving forward.
Ms. Khan, what are their agreements?
Judge, for temporary orders, they're agreeing to joint managing conservatorship with mom being primary, Montgomery and contiguous counties, standard possession order. Dad will pay child support of $2,163 per month starting February 1st. And the child is covered for health insurance through the CHAMP VA through dad.
Okay.
Let's pause here, because what was just read into the record matters more than people realize. These are temporary orders, not final rulings, but temporary orders often set the tone for the entire case. Joint managing conservatorship means both parents retain legal rights, but with mom designated as the primary, the child's residence is anchored with her for now. Dad is ordered to pay over $2,100 a month in child support starting immediately, and health insurance is already accounted for through his veteran benefits. That tells us the court is prioritizing stability right out of the gate. Nothing here suggests punishment. It's about structure. But notice how quickly the conversation shifts from agreements to conflict. The moment drug testing enters the picture, the atmosphere changes completely. This is where family court stops being procedural and starts becoming personal. And the way each side responds to that request is going to carry serious weight with the judge.
Okay. Is he in the military?
Was
In the military. Was a veteran. Okay. Got it.
okay. At this time, I would call Miss Williams. Miss Williams, can you state your name?
Thank you, Deshae Williams.
Okay, and are you in agreement with everything I just read into the record?
Yes.
All right. And you understand that dad is asking for you to do a hair follicle drug test. Are you okay with doing that?
No,
Why not?
because I'm not okay with doing it because this is another one of his manipulation tactics that he has. The reason why I love him is because he's abusive. And he is on record domestic violence, and I don't agree with that. I do agree with a urine test. You said a hair follicle randomly.
This is the first major turning point. A hair follicle test isn't random, ongoing, or indefinite. It's a one-time request, fully paid for by the father. But the mother's refusal isn't framed as inconvenience or logistics. It's framed as manipulation. That word keeps coming up, and it's important. From her perspective, this isn't about drugs at all. It's about control continuing after separation. From the court's perspective, though, refusal without a clear logistical barrier can raise questions. Family courts don't love invasive testing without cause, but they also don't ignore resistance. What you're seeing here is two narratives colliding. One says, this is harassment. The other says, this is concern. And the judge hasn't picked a side yet. But you can hear the tension building in how carefully every answer is being examined.
I don't agree with that.
Okay,
But
so what we're
So what exactly is he asking for? Just so she knows, and I know.
we talked about a 5-panel hair follicle test to be done at Davis Investigations in Conroe before tomorrow, Friday at 5 p.m. and dad is willing to pay for it.
So we're not talking like
because I
random,
work.
ma'am, one moment.
I'm
So we're
sorry.
not talking like random testing. We're talking just one time, like tomorrow. Is what he's asking for. Is that true, Mr. Williams?
Yes, that's true.
Okay, you can proceed, Ms. Khan. Now that we all at least are. So a 5-panel hair follicle tomorrow, which I think she's about to say why she can't go tomorrow, but let's proceed.
All right. So Miss Williams, are you able to do that hair follicle test tomorrow?
No, ma'am. I work and I took a sub position job,
So
What
you're a
kind of work do you
substitute.
do?
a substitute teaching right now.
So you get out when school gets out?
Yeah,
Okay, so are you working in Conroe?
yeah.
So you would be able to make it, it's right in downtown Conroe, so you would be able to make it there after school before 5.
Before
Wouldn't you?
5 today.
Or tomorrow.
Or
And if
today?
we don't
Yes.
make it before 5, what happened?
We're going to
What-
come back for temporary orders, and so the judge will at that time determine where the child lives and all of those things, but we'll be using.
If we disagree with this, what is the next step?
All right, I'll talk to you about that later. There's really not the time for questions right now, but I guess the question really is just what is your objection to doing a hair follicle test tomorrow
Okay.
if dad pays for it?
Manipulation.
Okay. Would you agree to a urine test?
No. I don't agree to anything, but I agree to a urine test. That's fine. I don't agree to any of it, but it's fine.
So I don't understand. Why would you agree to a urine test and not to?
I don't.
agree to a
I
hair
just said I don't
follicle
agree.
test?
I don't agree to neither one of them, really, ma'am. I truly don't. I don't want the drug. I don't want that. I don't agree to it because it's manipulation.
What do you mean by manipulation?
Manipulation. He's trying to manipulate accusations on me and trying to insinuate that I need to take a drug test so he won't be responsible for paying child support.
Okay, I pass the witness, Your Honor.
Okay, you can call your next witness.
Call Mr. Williams. Mr. Williams, can you state your name?
Randy Williams.
And you and Miss Williams are still married, is that correct?
That is correct.
And you filed for divorce, but there's no divorce pending right now, correct?
Right. 2024, I filed for divorce. Went to the hearing. Ms. Williams, my wife, did not show up to the hearing. And so at the time, the judge kind of, we on and off the record, talked about, trying to reconcile.
Okay.
So we were kind of left at that. I did a no suit at the time. So when you look at the records, it shows that it's a no suit.
So did you hear the agreement I read into the record as far as the custody and child support? And is that your agreement?
Yes, that is my agreement.
Okay. And are you asking that mom take a 5-panel hair follicle test by tomorrow that you are willing to pay for?
Right, exactly.
And
I'm willing to pay, I'm willing to pay for it. I'm willing to get her transportation, Uber, whatever needs to be done to get her to that location. If she's gonna lose, hours at work, that could be put on record too. That needs to be done, taken care of as well. I'm willing to take the liability on that part as well, if need be. I just
Okay.
have concerns, that's all.
I passed the witness, Your Honor.
Sir, what are your concerns?
Well, my concerns, my concerns are like, one, she is my wife, and she's as far as presenting herself as a, can as far as going to work, having 2 master's degrees, been out of work since April of last year. I've been, helping her with a lot of her bills.
I get I don't mean global concerns. Why specifically are you asking for testing, drug testing? Because most cases don't do it. Now, I'm not saying no cases do it. I do order them sometimes, but usually because there's a reason.
Yeah, because it just, because of her demeanor, the way she's been, her posture, the way she's been, acting around, it just seemed like it might be something there. That's all. I'm not accusing her or anything, but it's possible that there may be something there. That's all. I mean, that would be something that she would have to, battle with her own self, you know.
She had a history of drug use or anything that would. When people separate, they act differently sometimes.
Oh,
So
well,
and I don't usually order. I'm not thrilled to not order it because her refusal is a little strange and some red flags. But your reasons for asking also raises some red flags. So I'm a little.
This moment is huge, and it's subtle. The judge is openly acknowledging red flags on both sides. That doesn't happen often this explicitly. On one hand, the mother's refusal raises concern because courts expect cooperation when a child's welfare is questioned. On the other hand, the father's reasoning is shaky. Demeanor changes, posture, behavior, not concrete evidence. Judges don't like speculation. They want facts, and here neither side is delivering a clean narrative. This is the judge signaling, I don't fully trust either explanation yet. When a judge says they're not thrilled about ordering a test, that means the decision is being weighed carefully. This isn't automatic. The next few exchanges, especially admissions, tone, and consistency, are going to decide whether the court steps in or backs off.
well, I'm not here uh, my interest is the best interest of my child, what I'm saying, of our child, you know. And when I look at a long-term situation, it's not so much of the paying the money and all that kind of stuff. It's the matter uh, of his rearing, of
Well, and I guess you're just saying all I'm hearing is I want her to be tested because there might be something, but I mean that could be true for anybody. And I don't usually do an invasive test unless there's a reason for it. That being said, ma'am, the best way to prove someone wrong is to go get tested and come back and show, hey, I'm not doing drugs. But that's usually when they're accusing you of doing drugs.
That's correct. Oh, can I talk? I'm sorry.
No, not right now.
Oh, yes, ma'am.
yeah. But
Do you think she's using drugs? I guess I'm confused as to.
yeah, I think she's using drugs. Yeah.
This is where things cross a line. When the father finally says, yes, I think she's using drugs, the entire hearing shifts. This is no longer implied concern. It's a direct allegation on the record. And notice how quickly it's followed by uncertainty, prescriptions, pain, behavior changes. That lack of specificity matters. Courts understand that people change during separation. Stress, depression, illness, those alone aren't evidence of substance abuse. But once an accusation is made out loud, the judge has to address it. Ignoring it isn't an option anymore. This is also the point where credibility becomes everything. If the test is ordered and comes back clean, this allegation could backfire hard. The courtroom now isn't just deciding logistics, it's deciding whose version of reality holds up under scrutiny.
Why do you think that?
Because she's always saying that she's in pain and stuff like that. So she may have a prescription. I don't know. You know what I'm saying? She may be. I mean, she's had prescriptions in the past, and she may have beyond a doctor's care, but but from what I've known her, to be up and moving around and stuff like that, and being rambunctious, that's not her regular character. Her character has changed a lot, so that's why, I'm thinking that there's something there.
About you. Oh, no worries. Not a chance to get there. What's really different? Grooming?
Ms. Williams, is there anything additional you'd like to say?
Yeah, hurry, bring over here. We've been sitting there. Yeah.
Ms. Williams, are you still with us?
Yeah, but he didn't get to
Ms. Williams, just so you know, in the future, when you have hearings, if you can arrange a time where you're available, that would be much preferable. The district courts would not be happy with this.
Hello?
You back, ma'am?
I'm sorry, my apologies. My earpiece had went out and I couldn't hear anything.
Okay. Well, we can't see you right now. And you seem like you're moving around. So get situated so we can conduct our
I'm
hearing.
situated. I'm situated now, ma'am. I'm sorry. My earpiece had went out and it was in another room.
So do you need him to repeat what he just said? What was the last thing you heard,
Yes.
ma'am?
The last thing I heard was he doesn't you was asking him what's the reason why. And that's the last thing I heard.
Okay, so if you can answer again.
So the reason why,
Mhm.
your demeanor, the way that you usually operate on a normal basis, has not been the same. You know, majority of the time you're either under pain or laying in bed. I'm not sure if you're under doctor's care or some type of influence. So,
Of what?
and
Influence of what?
I don't know. You know what I'm saying? I'm not saying if you're under any influence. If you're not under any influence, it'll be such easy just to go and get a hair follicle and be done with it. I'm willing to pay for it. You don't have to pay any money for anything. So that'll be the end of that. And then you'll get to your 2160 that you want a month, for the next 3 or 4 years.
So you have
Uh,
not been with me. You have accusations against me, assuming you don't even know what's going on with me because you have not even been with me. So for you to have those accusations, that's
Ma'am,
incorrect.
this is not a back and forth conversation. Okay, was there anything else you wanted to say, Mr. Williams?
No.
Okay, Ms. Williams, is there anything you'd like to say to me? You're not talking to him, you're talking to the court.
Ma'am.
There's nothing else you would like to say?
I just don't agree with what he had. The reason why I don't agree with this because, like I told you earlier, it's manipulation. I left him. I had to leave to go to Montgomery Women's Center because I'm getting my ass beat by him. This is another part of his tactic. That's why I don't agree with the situation. Not the fact I don't agree with taking a test, but not because he's trying to control.
This is the emotional core of the case. The mother introduces allegations of domestic violence, referencing a women's center and prior jail time. That's not minor, but notice how the judge immediately reins the conversation back in. Family court requires documentation, not just statements. These claims may be real, serious, and traumatic, but without evidence presented today, the judge can't rule on them yet. Still, they don't disappear. They're now part of the record. This is why these hearings are so complex. You're watching safety concerns, parental rights, and credibility collide in real time, with a child's best interest sitting at the center of it all. The judge is walking a tightrope here.
My life again. If you look it up, he went to jail. He went to jail because of this.
Okay,
under
this
false,
is not, sir.
under false accusations.
Okay, well,
Falsely.
okay. Ma'am, what time does school get out?
3:30.
Okay, so you do have plenty of time to get there by 5. I'm going to order the testing. I'm ordering that he pay for it. Ma'am, this is the quickest way. When that comes back, not showing you don't do drugs, I'll know you don't do drugs. Like it's just going to knock it in the hole. Like this has nothing to do with him. This has everything to do with the best interest of your child, and the testimony I've heard. So I'm going to approve the temporary order as read into the record and render judgment. And I'm ordering the 5-panel hair follicle test to be taken by 5 o'clock tomorrow. Mr. Williams is going to have to set up the payment ahead of time. And then what reset date do you want to use?
So what's the reason? So what's the reason for this drug? What is the reason for this? And so if some,
Ms.
what's the
Khan,
reason?
what reset date would you like to use?
We worked out to April, I think. April. You want to do April 23rd?
I guess we can do April 23rd.
Okay.
Okay, the state's going to draft the order based on my ruling, and we'll reconvene on April 23rd. I'm just going to let you both know the state does not represent either of you. You are both free to consult lawyers if you wish.
Here's the legal reality of what just happened. The judge ordered the hair follicle test, not as punishment, not as validation of accusations, but as the fastest way to resolve uncertainty. The burden is shifted temporarily, and the father bears the financial responsibility. The temporary custody and support orders stand as agreed, and the case is reset, not closed. This is classic family court logic. Eliminate doubt, preserve stability, and revisit with more information later. The judge is making it clear this isn't about either parent winning today. It's about clearing the fog so future decisions can be made with confidence. April 23rd now becomes the date where everything could change.
Especially depending upon what happens with this test. But at this point, I'm ordering that temp order that was agreed to. So that's where this stands.
All right. Thank you, Judge.
Who
If-
agreed?
if-
Who agreed to that order? The temp order.
Okay. The state's going to help you all back to your breakout rooms. Thank you all.
So if you hit breakout room at the bottom, where it looks like a window with 4 squares, or say a circle with 3 that says more, you can hit
I
it
don't
and
see
it'll take you
that.
back to
But I
the
was
breakout room.
asking. I wanted to ask her about the temp order. I didn't agree to the temp order. I'm not on the phone when she said that?
Hey, Miss Williams, I'll go ahead and put you back in your breakout room and
At the end of the day, this case wasn't decided on accusations. It was decided on uncertainty. The court approved temporary custody and support, ordered a single hair follicle test to resolve competing claims, and set a clear path forward. No one was declared guilty. No one was fully believed. Instead, the judge chose verification over speculation and stability over chaos. And that's how family court often works. Quietly, cautiously, and with long-term consequences in mind. What happens next depends entirely on what that test shows and what evidence is brought back in April. Now we want to hear from you. Who do you think handled this hearing better? Was the test justified, or did it go too far? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.